Court calls the case of the people versus Mario Amison.
Alexander on behalf of the people, Your Honor.
Robert on behalf of Mr. Amison is approaching the podium. Amison, please state your name for the record.
Mario.
So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before
Judge Freshour.
Judge Freshour. Yes, that's the bond.
Your Honor, it's come to my attention that Mr. Amison has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What? 100 times?
100
Hold on.
times.
Okay.
Let me talk.
So I would be asking that his phone privileges be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amison in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge.
My bad. Go ahead.
Technically, it was, Judge, because it was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond. Or to I don't know. I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted. But we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me.
What do you want to say?
She came and visited me, man. They let her come visit me, so it couldn't have been that serious of a non-contact.
So, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and the
no domestic violence or nothing. That is false.
Yes, we got it. It's my understanding that the complaining witness has reached out to him several times, and so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. So that at this point we are.
Let me ask this then. Other than those times where the defendant is alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor,
some are from his pin and some are from other pins.
During a heated court exchange, Mario Amos faces scrutiny for violating a no-contact order, allegedly calling the victim over 100 times since arraignment. His attorney claims confusion, saying Amos thought it was okay since she visited him. But the judge isn't buying it, making clear, no contact means no contact, period. The prosecution pushes for restrictions, while defense insists Amos now understands. All eyes now turn to August 12th's preliminary hearing before Judge Freshour.
Well, I understand that, Mr. Burdell, there might be a mix-up when she comes there. And
I got one more thing to say, man. You ain't wording it right, man. Excuse me. Can I talk? I know how to talk. You feel me? I got you. She came.
Sure, go ahead.
She came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. How is she able to visit me if it's a no contact order and I'm in jail?
That I don't know, and that's why I asked if there were. I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that. Then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
Right. Well, I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir. I don't.
Because they telling you half the story, man.
I'm not gonna get that information right now. I'm not supposed to have that information right now. Anything else, Mr.
No, Your Honor.
Anything else, Mr. Bedell?
No, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making now, either from his own pen or from other pens, because that is not allowed and strictly prohibited. The defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination.
Thank you.
Thank you.
Man, you fired, man.
What'd you say?
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. Let's go. I'm gonna pick up the next one and just. This is on your advice, because I got something to say. But I'm not going to.
Drama erupts in court as the defendant insists he misunderstood the no-contact order, claiming the victim visited him in jail. So how could it be serious? He argues it's just a $30 fraud case, not domestic violence, and says the system's only telling half the story. But the judge isn't having it. Phone privileges revoked on the spot. Any future plea to lift the ban? That's up to Judge Freshour at the next hearing.